As the court, please.
Yes. And so, let me, for the record,
yes,
I will, for the record, you see, as I said, I indicated to you in chambers, I take responsibility for my acts. For the record, I'll apologize to you, and I'm apologizing publicly for making reference to your personal character. That I apologize, unreservedly.
No problem. Thank you, my lord.
Yes.
If I may just, because now the arguments, we have dealt with some of the, and I just wanted to put, obviously, the correct context of Mr. Amupanda's case. And I will do it in short summary.
Mm-hmm. But what you must know,
yes,
what I am concerned with at this stage is not his case. What I'm concerned with is, it's his evidence. Does it meet the basic elements of what he's asking me to do? Let me ask you this question.
Yes.
When you say, I must, for example, review and set aside the decision. When I make an order, which decision am I identifying? It's a decision taken by whom? Taken when? And taken where? And taken on what basis?
The decision to retain the
As an example, who took the decision? Mm-hmm. When was it taken?
First of all, my lord, the fact that the veterinary cordon fence was retained is not in dispute.
No. That you asking me,
yes,
to review the decision.
Yes.
Now I'm asking you, when was the decision taken? By whom was it taken? And where was it taken?
The decision to retain.
Yes.
That order is order number 4, my lord. Let me just go there.
No, I'm just demonstrating to you. You want me to make that order. And I'm asking you, did your client tell me which decision, when it was taken, who took it, and where it was taken?
Mm-hmm. Yes. And that is the problem now I have is, my lord, is this, that what the client have said, it appears that it cannot be considered because it's in history. It was at a time when he was not there. So if I have to refer you, I have to take you there. Unfortunately, the court is not interested in going there, and I don't want to disturb court on that.
In review proceedings, when you want to challenge a decision by whoever, a public functionary, you call for the production of the record in terms that will then enable you to identify the decision maker, the time of the decision, and the rationale for the decision.
In application,
it doesn't matter. Even in action proceedings, you want to review the decision of a public functionary. You must call for a record that demonstrates when the steps that led to that decision. You haven't.
That's why I wanted to take you to the orders, my lord. An order reviewing and setting aside the decision of the first and second defendant to retain the veterinary cordon fence. The decision of basically the minister.
When did Mr. Schledwan become the Minister of Agriculture?
I don't know.
It's a notorious fact that it's in 2005 or 2015. He was first a permanent secretary, he was a Minister of Youth and Sport, but the retention of the cordon fence, that came with the Constitution in 1990. So how can you say, where is the evidence that Mr. Schledwan took that decision? Where is that evidence?
We are not saying Mr. Schledwan.
You're saying the decision of the first and second response. That's what you are saying.
The first respondent is the Minister of Agriculture, not Mr. Schletvin.
He is the current Minister of Agriculture. You can refer to no other minister but Mr. Schlettwein.
So only his decision we must bring here, my lord, not any other person.
I don't know why you keep
occupied.
on asking me what you must bring here.
Because
are you going to pay me for legal advice, or what do you...
No, my lord, I'm very
So why are you keeping on asking legal advice from me?
Because I'm surprised that I bring a functionary, the Minister of Agriculture, and my lord, you're saying the person who I must talk about is the person who currently occupies that position. I must not talk about any other person who occupies that position. I never said that.
You must listen to me. I never said that. I said to you, the current Minister of... I said to you, the first question was, when did Mr. Schlettwein become the Minister of Agriculture? You said you don't know.
Yes, I don't know.
Yes, and then I said to you, it's notorious, it's a public knowledge that he became Minister of Agriculture around 2015 or 20. And that with the coming, and I'm telling you, it's a notorious fact that with the coming into force of the Constitution in 1990, the Cordon Fence was there and it was retained in terms of the Constitution. So which decision do you want me to review and set aside? Which decision do you want me to review and set aside? Taken when, taken where, and by whom?
I'm listening, my lord. I'm listening.
No, I'm not the one to answer questions. If you want me to answer a question, let's arrange another session, not this one.
My lord, with those exchanges, I'll say it has become difficult to argue this case, or impossible. We will stick by what is in our heads of arguments, my lord, and we submit that the case has been made out, for that the absolution be dismissed, and that an issue of cost, we make common cause with the rest of the defendant, my lord. Those are our submissions.
Thank you. Mr. Stein, is there anything to reply? No. Mr. Heathcote, is there anything to reply?
One thing, my lord, with your leave, I assume that the article in its working paper 4 has been given by your lordship for explaining to our learned friend what could have been used by him. And also, of course, your lordship can read the book. The book will actually tell your lordship exactly what this tells. That there's a chapter that says it was erected in 1960. That's chapter 7. Chapter 6 is inserts for the red line, which tells you that there was no fence erected by Linda Q and what have you. But the difficulty with these, my lord, is simply this, and that is, it should be ignored because your lordship can take judicial notice that in 1990 there was a fence when we got received our independence, and that it remained from then. And my learned friend's argument reinforced what I said, that Mr. Amupanda thinks the fence was erected by Lindeki and it's still the same place. And there is evidence before your lordship by the maps, permissible evidence, both maps, that those are far apart and that he's got his facts wrong and his complaint. For the rest, I just urge your lordship, it is a political case and not when you write your judgment to choose any party side, because that is exactly what the separation of power on a political level, I mean, not to say or do anything politically, because that is what the separation of powers argument is. And just address this on the facts, because what was presented to your lordship was never intended for a winning case. It was a dismal performance, but it served a political purpose. Those are the submissions.
Mr. Pelsa?
My lord, may I provide you just two
references? Yeah, you need to be on record.
Thank you, my Lord. Just two references that I just want to point the court's attention to. The court's engaged now with counsel for the plaintiff, saying that what the court is concerned about is not disputed. With respect, my Lord is correct. The transcript references are as follows: page 106, line 6 to 8, page 113, line 8 to 18, and transcript page 113, line 13 to 17. What that establishes is what my learned friend now for the fifth defendant has just said, that this absurdity that the court has put to the plaintiff's counsel, that two people who in 1896 have somehow cobbled together some sort of a fence, is what we are talking about that was erected in 1960s. The actual fact is that is common cause, that that fence has changed its shape and its size and materially its physicality, also its purpose. And there's another record reference that may assist the court, and that is on the issue of discrimination. There was only one ground of discrimination in Article 10.2 pleaded, and that is the ground of colour. It was pleaded in the court bundle, page 13, paragraph 29.7, and at transcript, page 209, line 28, the plaintiff conceded that the VCF does not differentiate on the basis of colour. So it is common cause, there is no discrimination on the only basis that was pleaded. Then the question arises, we have heard multiple times how counsel for the plaintiff asked the court questions. We understood the legal practice to be the opposite also in this country. The question that was asked is, can one discriminate? The answer is, the Supreme Court has said, yes. That is the answer to the question put to my Lordship. That's it, my Lord. Thank you very much. We are indebted to the court.
Yes, thank you. I'm advised that in terms of the practice direction of this court, I have 4 months within which to deliver judgment. But because of the importance of this matter, I'll do my utmost best to deliver judgment before the 28th of March. So I'll postpone to 27 March for delivery of judgment. If I'm ready earlier, I will alert you and invite you.
My Lord, if your Lordship would permit me, I just want to place on record, I didn't want to raise it during argument, but after our adjournment, Mr. Amupanda continues to breach he just posts, he fights his case on social media, and I want him not to do it pending your Lordship's judgment.
Shouldn't that be formally placed before court so that Mr. Amupanda can answer to it?
He can ask that, my Lord. Because it's like the rule is quite clear. When a case is considered and the court goes in consideration, you can't, I don't know why I forget the Latin word, but it's actually contempt, or to fight the thing in media. And he keeps on, I don't know what he's trying to do. Insults me, insults everyone that he can think of, and fortunately your Lordship is not reading social media, but it should stop pending the outcome of the judgment.
Tatantinda, do you have an answer to that?
My Lord, obviously I don't have instruction, and I don't know what my learned colleague is talking. To stop a person's rights, to take away his rights again, to do what is necessary.
What do you mean to take away his rights?
As it's suggested, to use his social media platforms.
No, the way I understand the complaint is that Mr. Amupanda is keeping on posting as regards the proceedings in this court.
What does that mean, my lord? He's posting regarding the proceedings in this court. He can't update anyone on his social media what happened in court, or he can't. My lord, the suggestion is just malicious. That is what I'll say. It's just a malicious
just hold on.
suggestion that somehow the court must make an order that Mr. Amupanda should not engage his social media, including his WhatsApps, I assume, that he should not communicate or use it to communicate to whoever. It's just a very malicious request, my lord. You know, my colleague.
My lord, may I then?
Just hold on. Let's listen and then.
May I then read what it says here from Mr. Amupanda, unless this is fake news and his name shouldn't appear. He tells us about what happened this week, and he says to achieve this goal, the defenders of colonialism are hoping that I'm unable to pay some fees they are mistaking, nothing will stop, and so forth and so forth. I will continue to fight. Then, my lord, he posts photos of not Namibian photos of a man being hanged with a rope around his neck. And my learned friend has got the audacity to say that I'm malicious if I bring this to the court. It should stop, with respect. We can't do this in a court matter. The issue is now sub judice, and it is a principle of our law that it must be honored.
Yes, I'm. Let me just claim it. I'm even speaking without instruction on those things. I'm not on wherever it was posted. I'm not on social media sites, my lord. And I assume that the court should not also be concerned about.
No. You see,
the social media.
I'm not on social, but what the important issue is this. Remember, Article 78 and Article 12 of the Constitution establishes courts for the courts to, without fear and favor and without influence from anybody, decide disputes between parties.
Yes.
Now, and the law has established that when a matter is before court, parties must refrain from commenting and making suggestions about that matter before court. That is the time-honored principle. So as to remove any impression of trying to coerce, to influence the court to come into a specific conclusion. That's a time-honored principle, and it must be honored.
It's a what, my lord?
It's a time-honored principle. It's a principle that has survived hundreds and hundreds of years. That's why there is contempt of court proceedings.
Yes. That's why I'm saying there is nothing. As I say, I'm even speaking without instructions.
Now, why do you speak?
Because you asked me.
No, then you could step down to take instruction.
Or you can bring, if there is any proper application for consideration.
You are an officer of this court.
It's really unfair that comments, somebody just come up and say, I'm reading from somewhere, Mr. Amupanda is doing this, Mr. How do I then even...
Okay,
we must just testify.
No.
Mr. Ithko testify, I testify, then the court... No, my lord, it's not the correct approach.
No.
It's really harassment when the case is continuing on how Mr. Next time you will be told that you hear Mr. Amupanda, the way he sleeps at home is not good, you must tell him. No, my lord, it cannot get that far. The court cannot be told.
It's not about him sleeping at home. It's about him commenting on a case that's before court.
The court cannot be influenced by
You see what I'm saying?
media.
I am giving you the opportunity to call Mr. Amupanda for him to deny or admit the facts. Full stop.
I'll do so.
Yes, I'm giving you the opportunity. Call Mr. Amupanda. An allegation has been made about him. Let him either deny or admit it.
Yes, he's just right.
Call him. He's here. He's not far. Let him come.
Come where, madam?
Now.
Where? To me.
Even your conduct.
No, my
Your,
lord.
your conduct borders on, there is a very thin line between debate and contempt. And I'm telling you, your whole conduct borders on that thin and gray line of contempt of this court. I'm telling you.
My lord, for telling you that there is no application, there is no, I don't
it's
have
not
instruction.
this is
I
an
don't
issue
have-
that is, it's an issue that is of paramount importance to the administration of justice. You can't keep on commenting about lawyers that are presenting a matter to court. You can't. That's an indirect influence and coercion. And the legal practitioner has the fullest right to bring it to the attention of the court. And this is what I'm saying. Call Tate Amupanda, let him come and either deny or admit.
I will do, because it's as instructed, my lord, I will do. I see he was here, but I think do we adjourn and I...
Yes, you can. I can grant. You see, I don't want to express myself without having given anybody an opportunity to say something about themselves. I'm going to adjourn. I'll give him an opportunity to. He even doesn't have to do it under oath. So I'm adjourning. When you are ready, let me know. Court will rise.
As the court pleases, my lord, I tried to get hold of Mr. Amupanda. Apparently he has left already. I even asked the instructing to get hold of him, but he has left already. I tried to call his phone as well, but it looks as if it's answered, but there's no talking, my lord.
Right, but you have an obligation, you have a duty.
Yeah.
Nobody's right is being infringed. Nobody's right is being curtailed. We have created institutions for ourselves. And those institutions must function. Whether you like them, you don't like them. You have different views. One for the orderly running of any and civility. Those rules that we have abided for and set for ourselves must be complained. So you have a duty too. So the matter, there is no way you can keep on commenting and making aspersions on parties who are appearing before court in a given case. That's an indirect assault on them. And that I will not tolerate. If you can just convey that. And this is not the first time Amupanda is going to come to court.
It's not this?
It's not the first time, it's not the last time that he'll come to court.
As the court pleases.
Yes, just convey that to him.
I will do.
And the court is there to resolve disputes impartially without undue influence. Yes, court will rise the matter is postponed to 27 March for judgment.
All right.
February is around the corner. I have Mr. Van Vieren keeping me busy for the next 3 weeks from Monday. So, no. Yes. 27 March, not 27 February. Yes.